हेलो फ्रेंड्स, हमने 3 चीजें देखी हैं इन्वेस्टर्स के साथ। 20-25 साल से एक सक्सेसफुल बिजनेस रन करते हैं अपने दोस्त के साथ, अपने रिलेटिव्स के साथ या अपने पुराने जिगरी यार के साथ। दूसरी चीज हम ये देखते हैं कि काफी सक्सेसफुल प्रोफेशनल हैं अपने ट्रेड में और बाद में कंसल्टिंग या जॉइंट वेंचर में किसी के साथ आते हैं एज दे मूव फ्रॉम देयर कॉर्पोरेट जॉब टू बिजनेस। हालांकि इन तीनों केसेस में एक फंडामेंटल फ्लॉ ऐसा होता है जिस वजह से ना ही केवल उनका बिजनेस रिस्क में रहता है, बल्कि जो सारी उनने जमा पूंजी इकट्ठी की होती, ऑल द वेल्थ दे हैव क्रिएटेड, वेदर दैट इज रियल एस्टेट, म्यूचुअल फंड्स, बॉन्ड्स, फॉर देयर फैमिली मेंबर्स, स्टैंड एट a risk. And also all the business that is currently being run is on a verge of collapse just because उनके पास वो 12 डॉक्यूमेंट्स नहीं होते हैं जो एक हर एक बिजनेस ओनर के पास होने चाहिए। और at least if he is 55 years of age he should start getting and compiling those documents. Hello friends, this is Rajat और आज मैं आपको बताऊंगा ऐसे कौन से 12 डॉक्यूमेंट्स होने चाहिए और क्यों होने चाहिए। We are talking today's the business owner's estate checklist. So now there are, as I have told you, there are 12 documents that you should have before 55. Now you could be a dedicated businessman already working in the space and running a very good consulting or a business with your friend or even to your relative. But the point is, the statistics say that only 21% of Indian family business leaders are having a documented succession plan. Good statistics that I would like to share with you. First and foremost, the single greatest risk to any business family would be like you have navigated the entire economic cycle over the years. काफी बार business zero पे collapse हो रहा था और आपने वहां से फिर से अपने business को खड़ा किया है. So 80% of the family businesses that fail at succession. Now you have been working for last 30 years. Now the second generation is going to come over or take over, or the second generation is not interested in that and they might be settled somewhere else. So how do you do the succession planning in that case? How do you do the business valuation in that case? And lastly, if there is an NRI, they are also lacking the proper estate planning because then there will be a cross-border chaos. So now the question is, why you should act now? At the age of 50, you still have 15 to 20 year window because till the age of 70, 75, you will still be working and doing business and being active. So starting at 55 is an optimal point to secure a transition. You have to transition your business to the next generation. For that, the planning has to start when you are say 55 years of age. What are the 5 pain points if you don't act? Now the question is, without documentation, your business actually faces these threats. First is operational paralysis. So what happens? There's a leadership vacuum. Say for example, something has happened to you. Now there could be a leadership vacuum which can lead to contracts being lost, vendors being disrupted. And now if you have not been there and your descendant or your son takes over, but then there is a conflict between your the son as well as another partner who could be an uncle or a friend of yours. So therefore, it could lead to the operational paralysis because there is no documentation of how these conflicts or these issues have to be handled. Second, there could be a talent exodus. So there could be two partners who have fell apart or there has been business succession issues. Now the team members might see that we are not able to see any growth here because there is an internal conflict within the organization. So the firm itself is not having a clear path, but rather there is a firefighting going on in between. So since there is an uncertainty about the company's future, you could also see executives moving. Third is your wealth erosion. Now, it has been seen that 20 to 40% of the enterprise value can be simply lost because there would be legal disputes and the management distraction. Family fragmentation. Now, the siblings could become adversaries. The relationships are actually fractured irreparably just because you have not documented how these transitions have to be controlled. Now, lastly, fifth, legacy destruction. Now, fewer than 30% of the family businesses survive the second generation, or at max, by second generation, your business or your legacy is actually done and dusted. If we see the real case studies in the matter, we have seen the Reliance saga. Now, Dhirubhai Ambani actually passed without a will in 2002. Now, this resulted in the public power struggle that every one of us is aware of. Now, the question is, do you have that privilege of getting stuck into the mud for the next 10, 15 years in the legal dispute? Is this the legacy that you want to leave for your family for that matter? The second case we have seen as a Birla-Lodha dispute. Premadas Birla's disputed will actually led to the 20 plus years of litigation which was undergoing into the Calcutta High Court. Therefore, if we look at 24-25, we have seen Sanjay Kapoor, Sona BLW Precisions, Godfrey Phillips and the Raymond. So therefore, anyone who has kept the infinite control in their hands has actually suffered. You might be thinking, okay, these are too big to be true for us. But even if you have a 5 crore turnover company or a 100 crore turnover company, the risk still stands. Legacy of your family, wealth and net worth of your family is actually at stake if not managed well. What are the 12 document framework we are looking at? First and foremost, we are looking at the foundation or the control. Second is the business succession, that is continuity. And the third, we are looking at protection. When you look at the foundation documents, what are the basic minimum requirement that you should have? You should have a comprehensive will. There has to be a family trust deed. There has to be a family constitution. There has to be a financial power of attorney. When you look at the business succession, there has to be a shareholder agreement, buy-sell agreement, business succession plan, and also key persons insurance. When you look at protection, there has to be a healthcare directive. There has to be an asset inventory and digital legacy, beneficiary nominations, and the letter of intent. Now, these are the 12 documents that you need to have. Now, when we are looking at the foundation documents, you are establishing a legal ground and rules for your asset protection. So, comprehensive will, what would it do to you? It will prevent interstate succession laws from overriding your wishes. So, unnecessary legal disputes, delay, your family will be saved of that. Must address business interests separately from personal interests. So, no, this is done, and it should be structured in the way where your business as well as your personal should be addressed separately. Second is a family trust deed. Now, it ensures tax efficient wealth transfer and it avoid the probate delays. So therefore, you can have a wealth transfer and still everything will be going on as usual. It is governed by the Indian Trust Act. Then there's a family constitution. What does this mean? It is a governance framework. It is a rule book which will determine your values, conflict resolutions, entry exit rules. Say, for example, there are two friends who are doing business together or two relatives that are doing business together. And now you have been there in business for the last 30 years. Two brothers or two partners having a conflict over a business decision. Who has a final say? For that matter. And if something happens to one member and another member comes up, it's like a constitution, it's like a law that should have. Having a family constitution when the business goes big and more family joins in, it is very important to have a family constitution book set up, which will have clear when and how any member can enter or leave the business. What are the values they should be having? How different conflicts can be resolved for that matter in the business. Then we are looking at the financial power of attorney. Now, it is very essential to prevent the business paralysis. For example, there has to be the frozen payroll or during the owner's incapacity. Now, financial power of attorney simply means if something has happened to you and you have become incapacitated, at least this financial power of attorney will empower another person in your family to take a call on financial matters. Say, for example, it has been written in your agreement or memorandum of understanding or articles of association, like any transaction more than 5 lakhs have to be jointly signed and approved by both the parties, both the directors. Now, one of the directors has become incapacitated. If it is already a financial power of attorney has already been signed and kept there, so it would give the designated person a right to take the calls and still ensure that business goes on. Pillar 2 is called as the business succession documents. Now, here, what is our focus? Our focus is protecting the entity, the partners, as well as the shareholders. Therefore, what documents we are looking at? We are looking at first as a shareholder agreement. Now, it governs the voting rights and the transfer restrictions. It should have tag along and drag along rights mentioned, because now today we don't have too much of time, so I cannot get too much on the specifics for it in the shareholder agreement. It will say what are the voting rights, what are the transfer restrictions, in which cases the share transfers cannot happen. Then there's a buy-sell agreement. It is critical for co-owners because it defines the terms for a partner buyout. So if there are two partners working in a business and in case of death, disability or exit, how that share can be bought or sold or transferred to the another party, and what are the other ifs and buts to in it, which could be the exceptions, whom it would not be allowed to be sold. Then there is a business succession plan. It is a roadmap for leadership transition from one generation to the next generation. Somebody is moving out, the new generation takes over. So what is a business succession plan? It includes successor training also and emergency contingencies. You are looking at successor training also. So then there is a key person insurance. So for example, there are the two directors working in the company. Having this insurance, it provides the necessary liquidity to fund a buy-sell obligations or cover cash flow during transition. Yes. So many times what happens if there are two partners and one partner has died. Now the net worth of that partner or ownership of that partner is worth say 10 crores. Now, if the spouse is not interested in being into the business and says, ki, okay, buy out our share, but the other partner might not have that much resources with him to be the absolute business owner, or he is not able to find somebody else, or at least he wants to make the payment and then search for the another partner or another director for that matter. But in the meantime, the firm or the company should have the resources to pay that 10 crore. Now, if the company doesn't have it, but if company has already taken a key man's insurance and the premium has been paid by the company, and if something happens to one of the partners, the insurance proceeds come to the company, and those proceeds are then used and paid to the spouse or any person from whom these shares are actually bought over, and then a business still continues without jeopardizing the interests of the other partner or the business or other shareholders. Pillar 3, we're talking about protection and healthcare documents. We're looking at personal care, the logistics, and the clarity of intent. What does this mean? Let us first get into the healthcare directive. It is called as a living will. It specifies the medical treatment preferences to prevent family distracting during the crisis. Suppose he has two children. Now, two children squabbling over who will take care of the father in terms of decisions with regard to the medical treatment, that could still be mentioned in the healthcare directive or a living will. How decisions with regard to his health or treatment or spending for those have to be taken care of, so that the family is not caught into distraction and debating rather than taking care of him. Now, the second is the asset inventory and digital legacy. There has to be a comprehensive catalog of physical assets and critical passwords and digital accounts. Okay. Then there are beneficiary nominations. What does this mean? It ensures the direct transfer of bank accounts. Having a beneficiary nominations. Now, beneficiary nominations are totally different from the basic nominations. I have already done one of the videos on this. Some of the products like life insurance nominations are automatically called as the beneficiary nomination. In others, cases like bank accounts, they are just called as nominations. Unless and until you don't have a will, and in will you don't nominate a person, then that person becomes actual beneficiary, nominee for that matter, and thus and receiver of the assets. So it ensures the direct transfer of bank accounts, demat accounts, mutual funds by bypassing the legal delays. Now we're looking at letter of intent. It is a non-binding personal message that provides context to your decisions and guidance. Yes, when you put as a letter of intent, it is non-binding, but you can put all your views, points, observations, the way you look at things, and to be managed there. Letter of intent is just like a document that will actually put on paper all those documents, what you have done, and the nominations and your expectations mentioned. And if you put it also in the letter of intent, that could technically be like a covering letter for all those things that you have done. And letter of intent has many other aspects that you can cover. Now, here is the main thing that comes up. When you look at cost of inaction versus the value of planning, what does this mean? If you're not doing anything, what would happen? Tomorrow, if the conflict happens between the two partners or in the family, could land your family back by 50 lakhs to 5 crores. The family could lose 3 to 15 years in the court battles, while these years could be used for building a legacy. So value erosion of the business would be 20 to 40% of the entire enterprise value being lost. So therefore, the intelligent people, the rich people, what they do is they actually typically plan. They take certain costs as investment. The planning cost could be your ranging between 5 to 15 lakhs, but doing so, they are actually protecting the assets. They are taking preemptive actions rather than doing a firefight and protecting their 5 to 500 crore worth of assets. So what are the intangible benefits other than that? There is a peace of mind. There is a family harmony. There is a legacy preservation for that matter. This represents one of the highest ROI investments in any business owner can actually ever make. Here is a framework that I'm going to provide you. If you take from the months 1 to 3, it is called as a foundation. Here what we do is we execute the will, we get the financial power of attorney done, there is a healthcare directive that is done, and there is a complete asset inventory that is completed. Once you do that, from months 4 to 6, we are looking at business protection. Yes. What we do here, we update the shareholder and buy and sell agreements. So there is a shareholder agreements, buy and sell agreements. We also secure a key person insurance. So there are these things we handle. Between 7 to 9 months is the time when we structure the wealth. What does this happen? You have to establish the family trust structure and you have to optimize other tax implications. So between The month's 10th and 12th is the time when the family governance take the front seat. So that is draft the family constitution and write a letter of intent. And then once you do that, there are certain things that are ongoing. There has to be an annual reviews for regulatory changes and the life events like marriage, births, etc. So now when you look at 12 documents, you cannot just wake up someday and say, okay, these are the 12 documents, let me make this. So that is now how it happens. Once you do it in a certain framework or line of action, you tend not to have certain things skip between the cracks, So that is the way the approach has to be. So now let me frankly ask you one thing. How many of you have these things actually updated? So if I put it estate audit checklist, how many of you are actually having these? For example, when we talk about foundation, do you have a will, trust, family constitution, power of attorney? Do you have shareholder agreement, buy, sell, succession plan and insurance, or having a healthcare directive, asset inventory, nominations and letter of intent? Now, once you tick these boxes, you have to make a scorecard. So if you are falling between 0 to 3, you have to have an immediate action. If it is between 4 to 7, there are significant gaps there. And if it is 8 to 10, you have to just focus on the things that are not there. So how we actually help you in this? So we normally follow a 5-step process. It starts with comprehensive assessment. We review your assets, liabilities, and current estate plans. So that is the first part. The second is identifying the gaps. That means identifying the missing elements, the risks involved, and the inefficiencies. Third, what is the custom roadmap? Now, based on each family, the tailored strategy has to be devised for wealth preservation and succession. So then you have to work for coordination. You have to collaborate with legal team, tax advisors, accountants for executing the things. And then there is an ongoing support. What does this mean? Regular reviews and adjustments for life events and regulations. So these are the 5-step estate audit process that is technically followed. Now, why you need to choose a Finogent? So we provide a holistic perspective, integrating estate planning with your financial strategy, getting all those estate planners on board, legal team on the back, getting the accountants also there and serving you well. Now, we have a very good business understanding. Let me tell you, we have an expertise in MSME and the family business dynamics, and we literally help our clients like anything. And then there's an NRI expertise that we do, handling cross-border FEMA compliances for that matter. So therefore, in order for you to secure your legacy, the first thing you need to do is to schedule your confidential estate audit consultation with us. So friends, you have spent all your life building your wealth, name, reputation, and it is a time where you have to pass on the baton to the next generation over the next 10-15 years. But for that, the first step or action has to be taken today. So today I have shown you, even if while you're doing business, in order to secure your business, these 12 documents you have to work towards, and make sure you have that in your locker so that your family is knowing that, okay, everything is in order and we are on top of the things. So you have to be in the top 20% of the people who are actually having all these things ready with themselves. Thank you so much. Reach out to us for any guidance. This is Rajat signing off.